Hi everybody, trademark attorney Josh Gerben. Today I'd like to talk to you about how to properly police and enforce your trademark rights. One of the biggest mistakes that I see business owners make is not having a proper enforcement program in place for their trademarks. And look, I get it. Any additional money that you have to spend on attorneys is not money that people normally want to spend. But in this case, enforcing your trademark can really shape the scope of the rights that you have long-term in your brand. It's really nice to file a trademark application, a few months later get a certificate in the mail and feel like the dollars were really well spent, right? You can just see the actual result comes on a piece of paper, nice shiny certificate in the mail. But with trademark enforcement, you don't get that kind of reinforcement that you're spending money correctly. The only thing that happens is you have less infringement on your brand in the marketplace, something that is not easy to quantify, like getting a registration certificate. So because of this, I find there's a lot of confusion about how companies should be spending money and how much to properly enforce a trademark in the marketplace. So in this video, I'd like to walk you through how to monitor your trademark and then how to enforce the items you find when you're monitoring. So the first part of any enforcement program is to properly monitor your trademark. And this typically means a couple of things. The first step is to set up a monitoring service for the federal government's trademark database so that you can monitor new trademark filings that get made that might be the same or similar to yours. If you identify a filing when it's first made, you can sometimes reach out to that party and stop an infringement before it even occurs. But this will also alert you to infringement that may be occurring in the marketplace that you were not already aware of. These types of monitoring services are typically done with a software and can be done through a law firm like ours or even yourself via a service offering that you can find online. The second thing you should do is have a Google alert set up for your important trademarks. This is really simple. All you do is create a Google account, put the trademark in, and it will send you an email anytime it recognizes that trademark being used on a website somewhere. This will really help you in monitoring for infringement of your trademark that's occurring when people are not filing trademark applications. And the final thing we recommend is constantly watching social media and ensuring nobody is infringing on your trademark there. This may just be hiring an intern or having someone in your company constantly scanning social media, being aware that any use of your trademark, not by your company, could be an actionable item and should be brought to your attention. So between doing these three things, monitoring the USPTO's trademark database, setting up Google alerts and monitoring websites for use of your trademark, and monitoring social media, you will be casting a very good net on anything that you need to be aware of and ultimately take enforcement action on. Now the second item here is how do we actually go about enforcing your trademark? And what I see a lot is that people think you should just send a very stern cease and desist letter anytime you discover someone else using your trademark. And that's not always the case. So when our monitoring finds a potential enforcement item for our client, there's typically one of three buckets that it falls into. So the first bucket is an incidental infringement, meaning the person probably didn't mean to do anything nefarious. They just flew a little too close to the sun. They have a trademark that's a little too similar to our clients in the industry, or accidentally used our client's trademark without really knowing of our client's rights. In this case, sending a very mean cease and desist letter would not be what we want to do. The second bucket is when someone's making use of your client's trademark and they know they shouldn't be. It's a nefarious infringement. In this case, starting with a very sternly worded cease and desist letter may be appropriate. And finally, there's actually non-actionable infringement. In other words, there may be sometimes you think someone's infringing on your trademark, but legally speaking, they may not be. Your legal rights may not be enforceable in that context, or it may not be a good idea to try to enforce your legal rights because you could stir up a whole host of other issues that ultimately becomes a really expensive and long and drawn out process for you. So it's really important to think about when you're doing enforcement, what bucket does this potential enforcement target fit into, and what should I do? Because there's a whole host of tools available to a registered trademark owner. Obviously, you could start with making the claim in a demand letter, as we talked about, but you could also file something called a letter of protest with the USPTO when you find the application early enough and ask the USPTO to deny that application because you believe it's too close to yours. You could even go as far as sending takedown notices on Amazon, Etsy, or other third-party platforms where someone's using your trademark in an inappropriate fashion. And of course, you could always file a lawsuit in federal court. But all of these items take time, cost money, and could lead to additional issues down the road. So you want to carefully evaluate what you do, and you want to think about how you reach out to the person that is the enforcement target. So now you can really think about trademark enforcement in two contexts. The first is that you have to monitor your trademark and make sure you understand who is using it and how. And the second is you have to figure out what is the appropriate enforcement steps to take when you do discover something. None of these steps are as simple and easy as filing a trademark application and getting the registration certificate. But if you do not enforce your trademark and police the marketplace, the rights you have in that registration will be eroded over time. And when you pull it out and try to dust it off 10 years from now because someone finally does something that just crosses all the lines, but you haven't done any enforcement up until that point, you may find it's incredibly difficult to actually enforce that registration. So a trademark registration has to be cared for from the minute it's granted if you want your rights to be as strong as possible. I hope you found this video helpful today. If you are looking at any type of enforcement action yourself or have questions about how to do trademark monitoring, you can always reach out to us at gerbenlaw.com and just fill out a contact form on our contact page. Thank you so much, and I look forward to talking to you soon.